Hi guys, I hope all of you are doing well. I'm Niladri Mukherjee. I'm a regulated Canadian immigration consultant. I practice in Mississauga, Ontario, Canada. So procedural fairness letter, response to the procedural fairness letter is something that we specialize on. We respond to a lot of PFLs. By now I have probably stop counting numbers, but we do respond to a lot of PFLs. And as a nature of our operation, I have seen practically all sorts of PFLs. 2024, however, is a little bit different, right? I see a lot of new different variations of PFL coming up almost every single week, and those are, in my opinion, are even more serious than what it used to be, such as non-declaration of the US visa refusals and whatnot. So a new nature of PFL, which is pretty new, like in the last few months, this has cropped up like significantly, is that you already have received your valid visitor visa, right? You might have traveled to Canada with that visitor visa. That might be 2 years back. Yet you receive a procedural fairness letter saying that, or asking you to justify one of the reasons that you might have stated at the time of your previous visitor visa application, and they are inactivating the visa, and they're saying that, well, till the time we get a satisfactory response, this visa will be invalid, and may most number of cases result in inadmissibilities because many people do not take that seriously. They respond to the letter by themselves without really understanding what it is for. They just provide like a half a pager kind of a response, and IRCC really does not appreciate that, and majority of those kind of responses lead to inadmissibilities. So PFL after a visa is sort of a new trend that at least I see for the last few months. Okay. Another thing is the rise of fraudulent bank statements, particularly from Africa as well as India. Okay. All sorts of bank statements have been either they have introduced, the agents or anybody else are introducing a new line item in that existing statement by adding substantial amount of money, or even that entire bank statement in many cases have been fraudulent. So this has always been the case, but the quantum of cases that I see of late have really skyrocketed. So that's something to watch out for, that if you're working with anybody unlicensed, which you should not be anyways, please make sure that whatever documents that the person is providing on behalf of you is being verified by you. Like literally each and every document, each and every letter, or whatever the person is providing for you should be verified by you, because you cannot say that, well, it's my agent did it, I didn't know it, because those guys do not exist in front of IRCC. The decision time is one trend that I could specifically comment on for 2024. The decision time for most of the procedural fairness letters have gone up, which means to me, tells me two things. Probably the number of PFLs have gone up, which I could probably say yes to it. Also, the analysis by IRCC. IRCC is investing way more time in analyzing each and every response of the PFLs that we sent. By we, I mean any representative or the client sent before they come out with a decision, because IRCC is aware that if you receive an inadmissibility, a ban, the repercussions are very serious for you. So they are also cognizant of the fact. In short, the decision making time after a successful PFL response has gone up significantly. On an average, I see a decision time of about 3 to 5 months, sometimes even more time than that. 6, 7, even 8 months when it comes to the medical admissibility, medical inadmissibility cases. So the decision time has definitely gone up. Other aspect that I could talk about are the medical inadmissibility related PFL. So if that is very specific to somebody who is either a Canadian citizen or a Canadian permanent resident and applying for a super visa or a visitor visa of the parents back home without knowing that their parents can potentially lead to, their parents medical condition may potentially lead to an excessive demand on public health and would lead to wait time. So the medical admissibility or the medical inadmissibility related PFLs have literally skyrocketed. So if you're thinking to consider applying for a visitor visa or a super visa for your parents, and if you think that your parents have any kind of medical condition, my recommendation and my serious recommendation would be to have them checked by their family physician, understand if they have any chronic disease and stuff like that, only then make those applications. It is very important that you take a proper consultation to understand whether though their medical conditions may potentially lead to inadmissibility issues or no, because Once they send you the PFL, it's your responsibility and you have to respond to the PFL. If you do not respond to the PFLs, they're going to put an inadmissibility charge on you. So that's a very serious stuff that I think you should be taking care of. Another aspect that I could think of is the fact that because of the increasing awareness of the procedural fairness letter or the bans in general, let's say you know that you have submitted a fraudulent bank statement as a part of your application. Along with you, your cousin has also done the same thing. For example, your cousin has received a PFL because of maybe any circumstances. You are yet to provide your biometrics. Okay, so now that you know that your cousin may be banned, you are maybe thinking that, well, if I provide my biometrics, my application will be processed anyways, and if it's being processed, I will probably receive a PFL or will eventually be banned. So let's not even provide the biometrics. That's a dangerous step to be taken, because if you do not provide a biometrics, they are going to, I can give it to you in writing, they're going to 100% make you inadmissible. Not refusing that application, but making you inadmissible. So be very clear about before you take any decision of that nature, because a misunderstanding of the situation could prove to be fatal in nature, right? So procedural fairness letter is definitely one of the most serious aspects that one, in my opinion, should take very seriously. You may need a professional help, you may not need a professional help. It depends on your abilities to craft and write proper legal submission letters, and to understand whether it depends whether you understand the legal protocols of the Canadian, like Immigration Refugee Protection Act of Canada or the Immigration Refugee Protection Regulations of Canada or no. But at least I think it is worthwhile to take consultations from somebody who understands these kind of issues before you even think of responding to the letter. As you would know, we as an organization, we specialize in responding to the procedural fairness letter. So if you need our assessment of your situation, what you have to do is to hop onto our website, nuvonation.ca, book a relevant professional consultation, and I'll be more than happy to have a case specific discussion with you to tell you how you can take this forward from there. Hope this helps you guys. Bye now.